Right friends, welcome to revision class. This is 5th one and it will continue up to 30, and first and second we deliberated about various S&T related issues. 3 and 4 we deliberated on contemporary issues of world geography, and now we are going to deliberate on various constitutional issues, and next week once again we will come back with the Indian geography issues. Some students are asking about art and culture. Definitely that we are going to cover in 2 sessions, and S&T is not completed, it will further come on with sessions. World geography, one more session may be required, and Indian geography may come in 2-3 sessions, economy may come around 3-4 sessions. So, like that it will continue till we complete 30th session. Questions also will be up to 30, Q&A discussion will be up to 30, and during the last 10 to 15 sessions we will try to include intricate questions. So, this is the plan of action for civil services preliminary, and let us look at various polity issues. First one is pertaining to gender discrimination and religion, and here this issue pertaining to gender discrimination basically, not religion. So, here in gender discrimination, Bombay High Court allowed entry of women to Shani Shinganapur temple in Ahmednagar district of Maharashtra. So, where is Shani Shinganapur temple? That is in Ahmednagar district of Maharashtra. It is into the news. Second one is water is quite frequently in the news because of Kaveri dispute as well as Indus water treaty. Quite often one Mullaperiyar dispute between Kerala and Tamil Nadu, Palar dispute between Andhra Pradesh and Tamil Nadu, then Mandavi river dispute, that is between Karnataka and Goa, then Mahanadi dispute is there between Odisha and Chhattisgarh. Like this, Kaveri of course between Tamil Nadu and Karnataka. So, several river disputes are there, and under these circumstances relevant provisions of Indian constitution is very important from examination perspective. All of you are familiar with this bifurcation of union list, state list, concurrent list under 7th schedule under article 246. So, the powers are bifurcated, and here if you look at water, water is entry 17 in the state list. So, water is primarily in the state list. Here water, water supplies, irrigation, canals, drainage and embankments, then water storage and water power, these are all in the state list. And entry 56 in the union list talks about regulation and development of interstate rivers and river valleys. When the river is interstate, then it falls in the union list, that is 56. If it is not interstate, if it is within one state, water is particularly entry 17 in the state list. And at the same time, one important aspect, do not forget, article 262 of the constitution. Article 262 of the constitution grants parliament the right to legislate over the matters pertaining to entry 56. So, here one important point is for interstate rivers which falls under entry 56, now the onus is on parliament under article 262. So, parliament can legislate the matters of interstate rivers under entry 56, and neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any dispute or complaint. So, constitutional provisions are very clear. Please go through them because lot of river disputes appeared during the year. Then the next one, this is all of you are very clear. 7th schedule, article 246 bifurcates union list, state list and concurrent list. And doctrine of repugnancy, we will come to it a little later. Then there is a lot of debate going on with regard to uniform civil code. Where exactly uniform civil code stands? Uniform civil code is as per directive principles of state policy under part 4 of the constitution. It is a directive principles of state policy, and article 44 says that. So, the government should strive to ensure uniform civil code, that is the wording. So, it is under directive principles of state policy under part 4 of the constitution. And recently law commission, you may have a doubt, law commission is executive body, and at present law commission is 21st is going on. Each law commission tenure is 3 years, it is executive body, and this is 21st law commission. It gives recommendations to the government with regard to the speedy justice, how to ensure speedy justice to the people, that is the goal of law commission. So, law commission sought public opinion whether triple talaq can be abolished and uniform civil code should be enacted or not. Then the next one is curative petition. This is into the news. What is exactly the meaning of curative petition? Here with regard to section 377 of the IPC, I will tell about history. Section 377 of IPC talks about homosexuality, and the history, if you go, section 377 of IPC, it is against the order of nature as far as sexual intercourse is concerned, and here Delhi High Court said that section 377 is in violation of fundamental rights enshrined under articles 14, 15 and 21 of the constitution. So, the Delhi High Court said in 2009 that section 377 violates fundamental rights. Then subsequently Supreme Court set aside Delhi High Court order. Supreme Court said section 377 will stay, and subsequently Supreme Court dismissed review petitions also. Later on there were several petitions filed by gay rights activists, and now Supreme Court referred it to the 5-judge constitution bench, right. So, here original petition, review petition, then curative petition, and here the bench also said that there were 8 curative petitions seeking re-examination of orders of the review petition. So, here what is curative petition? Curative petition normally is heard by the judges in chamber, but this time Supreme Court agreed for open court hearing, and when curative petition is allowed, as I have already told you, original, then review petition. Once review petition was also dismissed, then the third step is curative petition, and curative petition is normally allowed whether the review violated the principles of natural justice. Supreme Court, before allowing curative petition, will look at 2 aspects, whether the review petition violated principles of natural justice, and the second one is whether the judges are biased. Under these 2 circumstances, Supreme Court can allow this curative petition, and this is normally heard by judges in chamber, but this time Supreme Court agreed for open court hearing. So, curative petition, a question is expected. Sedition is into the news several times. Article, or you can say it is a section, actually it should not be article, section 124A of IPC, section 124A of IPC 1860, that is into the news because of sedition charges. So, here sedition is conduct or speech inciting people to rebel against the authority of a state or monarch. It is the British era or colonial era legislation, or you can say colonial era section in Indian Penal Code, and here it is punishable with imprisonment for life. So, this section 124A of IPC created lot of controversy during the year, right. So, previous inferences, what is the exact meaning of sedition? Supreme Court inferred several times exact meaning of sedition. Supreme Court stated that persons can be charged with sedition only if there is incitement to violence in his speech or writing with an intention or tendency to create disorder or disturbance. And here another case, the Supreme Court said that criticizing and drawing general opinion against government policies and decisions within a reasonable limit does not incite to rebel, is consistent with the freedom of speech. So, this controversy is quite in the news sedition, which is section, and what is the punishment. These aspects you should have clear idea. And this section 66A of IT Act, this was in fact struck down by Supreme Court in 2015, and this is just similar draconian provision, and this was struck down by Supreme Court in March 2015. And I have listed here other stringent provisions under IPC 1860. You can go through them if you have time. Then another important point during the year is IPC sections 499 and 500. Supreme Court upheld. That means just like the section 377, which criminalizes homosexuality, similarly this sections 499 and 500. These sections of IPC prescribe 2 years imprisonment for a person found guilty of defamation. If I am making some unnecessary comments against you, you can file defamation case against me, and this sections 499 and 500 looks at defamation, and this came into the news and this will stay. Supreme Court said 156-year-old penal laws on defamation will stay, and Supreme Court once again felt that freedom of speech is not absolute. If I am unnecessarily blaming you, you have every right to file case against me, and provisions, or you can say IPC sections 499 and 500 will be applicable. Here the maximum punishment is 2 years of imprisonment, right. So here Supreme Court tried to balance Article 19(1)(a) and Article 21. Article 21 is right to life and personal liberty, and Supreme Court felt that right to reputation is inbuilt in right to life. You cannot separate right to reputation and right to life. So sections 499 and 500 will stay. Section 377, Supreme Court decided to go for curative petition. It referred the matter to the Constitution bench. Then this articles pertaining to President's rule in focus. Article 356, President rule can be imposed in a state if there is a failure on the part of state government in accordance with the provisions of the Constitution. One important aspect is two things. Basically, Article 356 can be imposed when there is breakdown of constitutional machinery or constitutional impasse occurred in the state. And at the same time, Article 356(3) says that proclamation imposing President's rule shall be laid before each House of Parliament and shall cease to operate at the expiry of 2 months, right. So, these are the provisions, and you have to recollect Bommai judgment. This is very important. So, here important points of Bommai judgment, please go through them. Imposition of President's rule is not immune from judicial review, and here it is judicially reviewable. So, the President's rule can be judicially reviewable to look at these three aspects, whether it was issued on the basis of any material at all, and at the same time Supreme Court or the High Courts can strike down the proclamation of President's rule if it found that there is a malified intention or based on wholly irrelevant or extraneous grounds. Similarly, Supreme Court will review based on whether the material is relevant to action or not. So, these are important points, and most important is imposition of President's rule is justified only when there is a breakdown of constitutional machinery, but not administrative machinery. Very, very important. Secularism is the basic feature of the Constitution, and state governments can be dismissed if they are guilty of non-secular acts, right. Then assembly constituencies. Here it appears there is some constitutional standoff, and some critics say that constitutional amendments are not required, but one issue pertaining to Andhra Pradesh and Telangana is here assembly constituencies are to be increased as per State Reorganization Act. The State Reorganization Act of 2014 says that assembly seats have to be increased in both the states, but here if you look at constitutional provisions, this 84th Amendment, 87th Amendment, amended certain articles of the constitution, and the present status is total number of existing seats in legislative assemblies are fixed based on 1971 census and shall also remain unaltered till the first census to be taken after till 2026. So, till 2031, literally speaking, assembly constituencies are freezed, but now as per State Reorganization Act, they have to be increased in both the states. Now a constitutional standoff appears and constitution required to be amended, but some experts say that this can be done without amending the constitution, but I have listed here the existing constitutional provisions. Then chairman of UPSC appointed and he took oath recently. But why I included this news is, what are the articles pertaining to the public service commissions for union as well as states? Article 315, 316 like that up to Article 323 deal with the aspects pertaining to Union Public Service Commission as well as State Public Service Commissions. Then Union Cabinet gave its approval for introduction of 2 bills in Parliament for certain amendments to the Constitution. Scheduled Tribes Order 1950, here Article 342 in the Constitution that deals with inclusion, exclusion of various communities as STs, right. Now, this is most important. Several times this money bills, financial bills, all these came to the news. Here the bills are classified as ordinary bills, money bills and financial bills, ordinance replacing bills, constitution amendment bills, and money bills and financial bills. Let us look at a question is definitely expected on money bills, financial bills. And another important aspect, don't confuse finance bill. Finance bill as part of budgetary process, finance bill is money bill, and don't confuse between finance bill and financial bills. Finance bill is different, finance bill is part of union budget, it is a money bill, but recent times what happened, several amendments or you can say several changes were made by including them in the finance bill. So, several changes or amendments to other rules and regulations or existing acts were made by including certain clauses to the finance bill that was into the controversy. And now let us limit our discussion between money bills and financial bills. Here financial bills, total you can say the bills which deal with fiscal matters, that is revenue as well as expenditure. Fiscal matters means revenue and expenditure, they are classified as money bills, financial bills category A, financial bills category B, right. So, there are 3 types of bills which deal with fiscal matters, revenue or expenditure, right. Now, Article 110(1) of the Constitution, it has got clauses from A to F as well as G. A to F clearly says what exactly is money bill. It involves custody of consolidated fund, contingency fund, like that, please go through it. And another important point is as per clause 110(1)(G), here A, B, C, D, E, F there is no problem, but 110(1)(G) is there, it specifies that any matter incidental to any of the matters specified here, any matter incidental to any of the matters specified here can also be treated as money bill. Here the basic point is incidental to any of the matters. So, 110(1)(G) is broad perspective is there. So, the interpretation is basically difficult. So, the interpretation of 110(1)(G) is causing the problem because money bill Lok Sabha is a supreme, Rajya Sabha literally has got no power, and under these circumstances sometimes the existing BJP government is trying to basically circumvent Rajya Sabha, or you can say basically want to keep everything with Lok Sabha. That is why some of the bills it is classifying as money bill, right. And here money bill, these points are very important. Money bill is a when it is sent to Rajya Sabha, it will be sent with an endorsement by Lok Sabha Speaker to the effect that it is money bill, that is one point. And second one is, money bill can be a government bill only, it cannot be a private member's bill, that is another important aspect. It can be introduced in Lok Sabha on the prior recommendations of the President. So, these three important points. Then here with regard to money bill under article 113, here the Speaker of House of the People will be final to decide whether a bill is money bill or not. Then the next one is procedure, I have given here, it is clearly mentioned. If you go through this procedure, Rajya Sabha has got literally no power, Lok Sabha is a supreme if you look at money bill. And now financial bills. Financial bills category A, financial bills category B. So, what exactly is financial bill category A? It contains provisions dealing with matters specified under 110(1)(a) to G. In addition to the money bill provisions, it includes other matters also, right. I may not be able to give any example now. Probably I may be able to give some examples in future while we are discussing questions and answers, and for the time being please understand it includes 110(1)(a) to G, that is money bill provisions, as well as other matters. So, here just like money bill, it can be introduced only in Lok Sabha. It is to be introduced in Lok Sabha on the recommendations of the President. So, I think this is there for money bill also, and once it has been passed by the Lok Sabha, it will be just like an ordinary bill. So, these are special provisions for category A financial bills. Two special provisions, one is, or you can say 3 points, one is not only including the clauses of 110(1)(a) to G, it also includes other matters. Second point is, it can be introduced only in Lok Sabha just like money bill. Next point, third point is, it is to be introduced in Lok Sabha on the recommendations of the President, and once the bill is passed by Lok Sabha, it is just like any other ordinary bill. So, Rajya Sabha will have the powers just like any ordinary bill. So, category B means it involves expenditure from consolidated fund, but it does not come into the category of 110(1)(a) to G. It involves expenditure from consolidated fund, but it does not come in the category. It can be introduced either House of Parliament, but here only the special feature is recommendation of the President is essential for consideration or passage of the bill and passage of the bill. So, this one special provision, it can be introduced in either House of Parliament, and otherwise it is just like an ordinary bill. So, this differentiates category A and category B, and we already deliberated about money bills. So, a question is expected on this in the examination. So, if I am able to give some examples of category A as well as category B, it will be very much clear to you, but at present I am not able to give any example. Then presentation of budget from 2017-18, three things happened. Please understand from the examination perspective. Vote on account was eliminated this year. Budget was presented on February 1. All budget process was completed prior to March 31st. So, from April 1 onwards, the new financial year has taken normally by eliminating vote on account. Then, general budget and railway budget were merged for the first time after 1924. So, 1924 railway budget was separated. So, again merged. So, in 2017-18 budget, railway budget and general budget were merged. Plan and non-plan classification was removed for the first time. So, these three important points please do not forget. Then this is the difference between regular budget, interim budget, vote on account. From examination perspective, this is very important. Regular budget means it looks at both revenue and expenditure for the whole financial year, and interim budget, it is per part of the year. maybe for 3 months, 4 months, 2 months, and it involves both revenue as well as expenditure. And if you look at vote on account, it permits expenditure only expenditure is permitted, it does not touch revenue part, that is vote on account, right. So, these things are very important. Then more on budget, please go through this. First budget was introduced for India on 7th April 1860, and here first budget of independent India was presented on November 26 by India's first finance minister R.K. Shanmugam Shetty. And please do not forget, constitution does not specify the word budget, but article 112 talks about annual financial statement for both revenue as well as expenditure. So, it is literally annual financial statement, right. Look at the next one. Article 142(1), this is into the news because recently the Babri Masjid case, in fact Babri Masjid case is where some of the Indian politicians are involved, that was revived by the Supreme Court by using special powers vested on it, that is article 142(1). To do complete justice, Supreme Court can interfere under article 142(1). Then assembly elections, it is not much news, but one important point, please do not forget, the maximum limit for the expenditure by the candidates in assembly constituencies is 28 lakhs, and for parliamentary constituencies they are 70 lakhs. And here this is the expenditure limit. Please remember, this is the expenditure limit by the candidate. It does not include the expenditure by his political party. That is the flaw here. Then article 245 and article 254, you should have clear idea. Article 245, Parliament may make laws for the whole or any part of the territory of India under list 1. So, here list 1 union list, list 2 state list, list 3 concurrent list. So, list 1 full power to Union of India, list 2 the legislature of a state can make laws for the whole state or part of the state under list 2. Here also there is no problem, but the problem comes for concurrent list. Concurrent list, here state can make laws, center can make laws, but the point is, if the legislature makes a law under list 3, please understand carefully, if a legislature makes a law under list 3 which violates the law made by the parliament, as I have already told you, under concurrent list both the parliament and state assemblies can make laws. But the biggest problem is when one law contradicts the other, what happens? In this case, parliament is supreme, right. So, this is known as doctrine of repugnancy, very important. So, parliament is supreme, it gives primacy to parliament. So, doctrine of repugnancy, please do not forget. So, if the state law is repugnant, it requires the assent of the president or the central government. That is why the cases pertaining to Jallikattu as well as Kambala, they went to the approval of president or assent of president, because already center's law is there, which is cruelty, which is preventing cruelty to animals. It is 1960 Act, if I am not wrong, and when Jallikattu or Kambala are to be allowed, it violates 1960 Act. That is why for Jallikattu and Kambala, the matter went to the assent of the president. So, this doctrine of repugnancy is very, very important. Then Karnataka passed Prevention of Cruelty to Animals Bill 2017, I have listed here, right. So, bill seeks to exempt Kambala from the Prevention of Cruelty to Animals Act 1960. So, it went to the president for his assent, right. Look at another important aspect. This is not about changing the chief minister in Nagaland, but there is one constitutional standoff in Nagaland. Here article 243T, article 243T says that not less than 1/3 of the total number of seats to be filled in direct election in every municipality must be reserved for women by rotation. So, the seats are to be reserved for women 33%, but there is one article 371A, this no act of parliament in respect of religious or social practices of Nagas, Naga customary laws and procedures. Naga customary laws and procedures that is incorporated in 371A. Now, the Naga groups say that article 243T, which prescribes 1/3 of the seats for women, is against this article 371A. Article 371A prescribes Naga customary laws and procedures, protection of Naga customary law and procedure. So, in future it appears constitution needs to be amended to make the things explicit. So, please understand this standoff between 243T and 371A. Right friends, we came to the end of today's discussion, and very important aspects are discussed today, and similarly we will have some more sessions on Indian polity and constitution, and we will come back to you on Monday with some other topic. Right friends, have a nice day. Please do join for questions and answers discussion within few minutes. Thank you.